Or Lordship only note, my lord, because it's a judgment which are there.
Find out any judgment
Yes.
which says that, in the circumstances that we are in,
Yes, my lord.
Anup Banwal judgment said that these are the norms that should be followed.
Yes, my lord.
Correct?
Yes.
These are the norms that should be followed.
Yes, my lord.
But it would operate in the interregnum
Yes, my lord.
till the parliament enacts the law.
Yes, my lord.
Is there any observation in Anup Banwal judgment
Yes, my lord.
that we are not directing
Yes.
parliament to frame a law,
Yes, my lord.
but as and when parliament frames the law, our observations should
My lord.
keep in mind?
My lord, directly it cannot, it does not, my lord. No court says. But what is the constitutional scheme?
Would have said so.
No, my lord, with great amount of
Would have
respect.
said so.
My lord, with
Because
great amount of respect, my lord.
a
No,
100 paragraph judgment
So 3 through 9 and all of it,
trying to support the view that the Chief Justice of India should be included in the committee
yes, my lord.
is only for the purpose of operation during the interregnum when
But-
there is a vacuum,
Yes.
and not beyond.
But it indicates what is the constitutional scheme.
For this, there was no such observation.
My lord, it can, my lord, no
Well,
court
that
will
will-
issue mandamus that you enact law
It's not
or
that
it,
you cannot improve.
No, my
They're
lord.
just asking
no,
for.
my lord, no, my lord, no.
Acha, in your term, if there is, we want to see that. First thing. Second thing, assist us by showing in course of the parliamentary debates,
Yes, my lord.
whatever you have shown from these two statements of Mr. Surjewal and other,
Yes.
we have not been too clear as to whether, a proper debate was there before the parliament,
Yes, my lord.
stressing upon the need to look into Anup Banwal judgment and then frame the law.
Yes. My lord, in fact, your lordship asked me yesterday objection reasons of this act. I somehow,
objection-
no, in objection reasons itself it says, Barnwal,
No, objects and reasons only in one paragraph recites that Anup Banwal judgment has come. This is what.
and what Barnwal says also is been calm, my lord. If your lordship, I'll just,
Second paragraph onwards, there is very little to help
no, my lord,
on a view
The
that
object-
Anup Banwal judgment
yes.
observations have been considered.
My lord, would your lordship just permit me to?
Just one intervention, if you lordship, on that question.
Ye,
One,
compilations.
when this bill was passed, 141 members of parliament of the opposition were under suspension. So, my lords, actually, the parliament itself, this additional point, 141 members of parliament were under suspension. So, there's no proper debate. Your lordship is right. And that's the additional point. I'll just raise it. Plus, 141 opposition members of parliament were under suspension, and that's when the bill is passed.
And the objection reason specifically notes, my lord, that Barnwal said Chief Justice of India should be a member of that collegium. Would your lordship permit me to, my lord, yesterday by mistake I handed over a wrong copy of the objection reasons, my lord, just the act and the objection reasons.
It was shown to us. Of the amendment. From the book,
Yes, my lord.
ROP Act, jo hai na, last one.
Yes, my lord, yes.
You see, it's only two paragraphs.
Two paragraphs. Basically, third is, my lord.
Doesn't throw much light.
No. May I read the paragraph 2? It is important, my lord. Would your lordship just see that? Lordship can mark it.
Book this.
Paragraph 2. Honorable
Six. 326.
Act.
Yes.
Yes. Paragraph 2, my lord.
Please place it.
The Honorable Supreme Court in Anup Barnwal has declared that the appointment of CEC and EC shall be made by the President on the basis of the advice of a committee consisting of the Prime Minister, Leader of Opposition in the Lok Sabha, and in case there is no such leader, the leader of the largest party in the opposition in the Lok Sabha having the largest numerical stand and the Chief Justice of India. It has been clarified that the aforesaid judgment will hold judgment that the said norm provided by the Supreme Court will continue to hold good till a law is made by the Parliament. So, my lord, it is notes, my lord, that what is the Anup Barnwal says. And I have...
It definitely it notes.
Yes, my lord.
But thereafter, while framing the law, whether the ethos that have been expressed in the judgment, whether this is considered or not, we do not get it.
My lord, that's what the challenge is. The Section 7 is contrary to, my lord, the constitutional. My lord, I'm not saying that Lordship do not issue mandamus to the Parliament, not say you frame a law. When a law is framed, Lordship checks, Lordship makes a judicial review to whether it meets the constitutional norms. What I am saying is, Barnwal and they've said that what are the constitutional requirement? It does not merely say, my lord, that this should be the composition. That's what I wanted to show to your Lordship, this paragraph, 7 paragraph, in which the...
Can you show your pleadings in the writ petition?
Yes, my lord.
You're in Dr. Jaya Thakur?
Yes, my lord. Please, your Lordship. I know. Does it mention a ground? Yeah. May I read the prayer first, my lord?
Yes.
Page 16. In the prayer itself, my lord, issue a writ, page 16, my lord, directions declaring section 7 and 8 of the Act as ultra-virus under Articles 14, 21, 50 and 324 of the Constitution, inasmuch as this violates principles of free and fair election, apart from being contrary to the principles laid down by this court in the case of Anup Barnwal and past such orders.
You are reading from...
Page 16 is my prayer, my lord. Of writ petition, my lord. My lord, have a writ petition? Writ petition 14 of 2024. I'm so sorry.
You were reading A.
Yes, my lord. Yes.
Please read once again. Issue a writ.
Issue a writ direction
7 and 8 of the Act.
The Act as ultra-virus so and so, inasmuch as they are violative of the principles of free and fair election.
Where is that? Inasmuch as violative of... We are not finding it there in the prayer.
My lord, in my copy, I have that.
Yeah, our copy is not...
I'm so sorry.
That is why I thought you were reading something else and we are looking at...
Yeah, my lord, Lordship has the writ petition 14 of 2024.
Jaya Thakur, 14 of 24.
Yes, my lord.
Our copy shows the prayer stops at 324 of the Constitution of India.
Yes, my lord.
There is nothing thereafter.
I do not know, my lord.
The copy we have has a two-part prayer.
Yes.
That has Mullah.
And
No, but we will be going by our copy.
yeah, lots of Lord, all of us has this, my lord. I don't know. I have this copy, my lord. I do not know.
Corrected copy. I can get the corrected copy.
Oh, this is the correct copy.
Must be, my lord. Your Lordship's
You
copy.
might have prepared notes. You have added something. Might have added something. But what
No, it normally
both of us are having is the copy.
it
Discrepancy normally should not even.
it does not happen, my lord. In that list, I have.
Yeah, you written. Mr. Farad sir, where is your prayer B here?
But there's only one prayer.
No. Prayer
Prayer
A,
and prayer
then C,
There. Where
then
is prayer
C,
B?
and then C, my lord. Yes, there.
No, not and then C. Yes. No prayer B. But our copy shows A and B. A is the main prayer that declares 7 and 8 ultra-virus. B
And-
is past such other further order.
Yes, my lord.
So where are you getting this from?
I
Not
don't-
there in our copy. We'll go by this only.
All of us has, my lord.
Now show us your pleadings. What are the grounds on the
If your Lordship
Basis
kindly
of-
come to my lord first paragraph of whether, my lord, I do not know.
paragraph?
Para one also.
Para 1, yes.
Para 1. It is the same in as much as the violative of principles of fair and fair election. I hope it is there, my lord.
It is there.
Apart from being contrary to the principles laid down in Anup Barnwal case.
So
And then, my lord,
to persuade us to hold that these are violative of principles of free and fair election,
my lord.
what are the pleadings? Let us see.
Yes, my lord. Para 5.
Now this is history.
No, my lord.
Para 5 is history.
No, it is not, my lord. It is a submission. My lord, it's a part of my submission.
No,
That in order to ensure that purity of election, it was thought by our constitutional makers that the holding of free and fair election in the country should be entrusted to an independent body which would be insulated from political executive interference. Well, this is part of my submissions. It is inherent in a democratic setup that the agency which is entrusted the task of holding election to the legislature should be fully insulated so that it can function as an independent agency free from external pressure from the party in power or the executive of the day. This objective is achieved by setting up an election commission, a permanent body under Article 324 of the Constitution. That the functioning of the election commission greatly determines the quality of governance and the strength of democracy. And in view of great constitutional importance of the election commission, the fairness and transparency in the mode of procedure of appointment of the chief election commission, its members become very crucial. Then 324 is quoted, my lord. Then then I have given, my lord, the para 10, my lord, that the practice of appointing members to the election commission without making a law adopt just, fair and transparent and by constituting an independent and neutral collegium committee for recommendation of the name is violative of Article 14 and 324(2) of the Constitution. Thereafter, therefore, petition approached the Senate court that was listed on so which already referred to Constitution bench. And finally, the writ petition is allowed. Barnwal is quoted, my lord, in para 12. And the same.
Any petition with better pleadings?
So the ADR is the second petition. That has far more details.
This is nothing.
My lord,
What is this?
my lord, this is what.
Article 32 petition, no specific pleading about the invalidity of 7 and 8 on the grounds on which you are raising.
No, my lord.
This grounds 8 to 10.
Para 13, I have said, my lord. Para 13, that the respondent notified the impugns section 7 and 8 of the Act, etc. In the above, then, my lord, the same grounds are given, which I.
You wish to succeed only on this statement, which is contrary to the above said directions passed by this court?
No.
Paragraph 13, look at it.
Yes, my
You are
lord.
reading paragraph 13?
No, my lord, it is not only on that ground, my lord.
You are
My lord,
relying on para 13, let us see what is the petition.
my lord, para 13, I have read it, my lord. Lordship has read it, my lord. My lord, what I am saying, my lord, it has to be read with along with the other paragraphs, my lord, page 7, 8, 9, para, which are there, my lord, in which we have, substantially it is that, my lord, it has to be out of the executive control. It cannot be solely in the executive control, my lord. Now, can I give your lordship?
In which writ petition do we find Mr. Farasat's claim that it was at a point of time when X number of members were suspended and all these? Are these on record? Or?
Intervene. I appear for intervene. In that intervention, I pleaded that 140 members.
In neither of the writ petitions
Petitions,
is there.
I'll double check ADR if it's there or not. But in my intervention, I've specifically pleaded that. It's there on record. So it's there in pleadings before your lordships.
Important matter.
Yes, my lord, it's there in my writ petition.
PDF.
It is there clearly. Clearly, my lord, ground J says, because the act was passed at a time when the majority of the opposition members of parliament was
So your number is?
84. दिखाई तो एक बार petition.
that is item 34.5.
34.5.
Petition civil 87 of 2024. 87 of 2024. Association for Democratic Reform versus Union of India. 34.3.
Association for Democratic Reform.
Yes.
In fact, we read it and be prepared.
Which paragraph, Mr. Bhushan?
Page 32 in the ground J.
Page 32.
Ground J. Because Act 2027 was passed in the Lok Sabha on 21/12/23 at a time when the majority of opposition members of parliament were suspended by the Speaker, Chairman of the Lok Sabha. These members of parliament were suspended without any sufficient cause and only for asking the Home Minister to make a statement about a security breach which happened in past. This legislation was passed when opposition members were illegally suspended and in the absence of any debate, virtually any debate. There is one, your Lordship was asking, where were these issues raised in the debates? In the statement of Mr. Owaisi, who apparently was not suspended, he has said very, very clearly and sharply
Volume 2.
that this act goes totally against the Supreme Court's judgment in Anup Baranwal's case, and it makes the appointment of the election commissioners totally on the subjective satisfaction of the government. It is very clearly and at some length, my lord. And in fact, my lord, there was no attempt, it seems, by the government to defend this at all. They just said that we move a resolution that this should be passed, and in a voice vote, it was passed. No, not even any division.
In fact, based on this note, we have a contended note about the legislative legitimacy, right, based on this ground, taken by Mr. Bose.
My lord, Mr. Owaisi's statement is there in volume 2, my lord, page 190.
Just one
I'm so
minute.
sorry.
ये देखो
Yes,
please come to page 35 of your writ petition.
yes, yes. Yes, sir.
See the verification part.
Verification, I, the above named deponent, do hereby verify that the contents of the above affidavit from para so-and-so to so-and-so. It's blank. I know, my lord, sometimes this happens.
No. You know, this is the experience that we have been having here only in the Supreme Court. We don't have it in the High Court.
No, that may
This
be.
is the way.
Sometimes.
Such an important. Yesterday we declined the prayer for adjournment, saying this is such an important matter, and this is how petitions are filed. One petition of Mr. Hansaria we have seen, no pleadings. This is in your petition, right? And this is not the way, to verify paragraph J. There has to be a specific statement. Somebody has to take responsibility for that statement.
Actually, it is there in
Let us
multiple
see the
places.
Supreme Court rules.
In the multiple places in the petition, we have stated so in the synopsis and in the facts, recitation of facts.
When you make a specific statement, you have to take the
I agree,
responsibility.
Lord. Your
Right.
Lordship may take it that
You will have
it
to cure it,
was meant
otherwise
to be the whole thing.
you'll have to.
Meant to be from the beginning till the
It
end.
has to be cured.
Now,
You don't
Lord,
say that on this
Mr.
ground we will not entertain, but you have to make it in order first.
Mr. Chokar, who had signed the affidavit, has unfortunately passed away. He passed away last year. But
to 61.
but I can say, my lord, that everything stated in the petition, writ petition, was meant to be verified, Everything he has stated is factually correct.
We are not we are on the phone.
I agree.
We are not on substance.
I
But
know.
when the Supreme Court is approached for a decision on such an important issue, I will simply not say that very well. We'll go by the substance.
I
not by
agree,
the
my lord,
form.
sometimes.
This will not set a very good example. Then don't have petitions, don't have verifications, don't have affidavits.
Sometimes, my lord, what happens is
Not
that
sometimes.
clerks.
This has been our major experience.
Anyway, my lord, if your lordship wishes.
Just 1 minute. Let us see what our rules provide.
Mhm.
Name and mission.
No counter is filed in any of the petitions.
We can file, if your lordship wishes, I'll file.
We will grant you that.
No difficulty about that. We'll do it today itself.
Learned counsel, if you want to play with your mobile, please go outside and play. Please go outside. Please, I'm requesting you. You're distracted.
Sorry.
You're running.
Was also, my lord, the main
Just a
petitioner
step
in the
what
earlier
was
case.
going on. Games and all. That's not
I
problem.
know, my lord, that happens sometimes.
Yeah. It's a curable defect, but
Yeah. I can do it. I'll do it by today itself, during the day itself, during the
Yes,
course of the day.
Do it. Yes, Mr. Ansari. Finish your argument.
May I please?
इसको इसी में बांधने.
If your lordship kindly see volume 3, my lord. I'll just give lordship, I only note the para numbers, my lord, that's all I want to say.
Volume 3, yes. Para numbers.
TN session judgment, my lord, which
Yes.
starts in the compilation page 63,
Yes, para numbers.
para number 10, my lord, at page 75.
Only 10,
My lord, 10 is sufficient for my purpose, my lord.
75.
Because the lordship asked me. At page 75. The preamble of our constitution proclaimed that we are a democratic republic. Democracy being the basic structure of our constitution, feature of our constitutional setup, there can be no two opinion that free and fair elections of our legislative bodies alone would guarantee the growth of healthy democracy in our country. In order to ensure that purity of election process, it was thought our constitutional makers and the responsibility to hold free and fair election in our country should be entrusted to an independent body which should be insulated from political and or executive interference. It is inherent in a democratic setup that the agency which is entrusted the task of holding election to the legislature should be fully insulated so that it can function as an independent agency free from external pressure from the party in power or the executive of the day. So, my lord, this is the principle which our lordship have laid down in session, reiterated in Burnwal, my lord.
Right.
And in Mohinder Singh Gill, my lord, only one that's a plenary power of the, that is in para 27, my lord. At para 38, page 27 of this, my lord, that the plenary power of the election commission, my lord.
Para 27.
Para 38, page 27, para 30.
That's a page 27.
Page 27, para 20, para 38.
One small request. Sir, one small request.
I'm so sorry, my lord.
This Anup Banwal, just tell me the number.
My lord, yes, my lord. Paragraph 38.3,
38.3,
para 86,
86,
222,
22,
250, 297,
97,
301,
301,
353,
353,
and 456.
456.
Please, your lord, sir.
So we have marked it, but
Yes, my lord. This at one place, lordship would get it, my lord.
Right.
Now, my lord, as I submitted, my lord, the independence of the election commission is as much important as an independence of judiciary. What your lordships have said in the second judge's case, to insulate judiciary from the executive interference, the principles which our lordship has laid down in second judge's case, and the reason why our lordship have struck down in the fourth judge's case, NJC judgment and the 99th amendment, my lord, I just want to lordship to note some paragraphs of one paragraph of each judgment, my lord. That the second judge's case is 1993, 4 SCC 441. Would you quote, Master, kindly? 1993, 4 SCC 441. Give me my software. At page 692, para 450, is Justice, my lord, Justice Verma's opinion, which is the majority opinion, my lord. And paragraph, my lord, 450.
450.
By Justice, my lord, Justice Verma, and Justice Pandyan's view, my lord, paragraph 203, page 567. These are SCC pages, my lord. At page 692, my lord, para 450, because Justice Verma's opinion is the majority opinion. It is obvious, I'm so sorry. at page 692. It is obvious that the provisions for consultation with the Chief Justice of India in case High Court with the Chief Justice of Court was introduced because of the realization that the Chief Justice is the best equipped to know, assess and word the candidate and his suitability for appointment of a superior judge. It was also necessary to eliminate political influence even at the stage of initial appointment of judge. My lord, that's what we are saying. At the stage of initial appointment, it is necessary to eliminate political influence, since the provisions for securing his independence after appointment were alone not sufficient as an independent judiciary. At the same time, the phraseology used indicated that gives absolute discretion or power or veto to the Chief Justice of India as an individual in the matter of appointment was not considered desirable. So there should remain some power with the executive to be exercised as a check whenever necessary. The indication is that in the choice of a candidate suitable for appointment, the opinion of Chief Justice should have a greatest weight. The selection should be made as a result of participatory consultative process in which the executive should have the power to act as a mere check on the executive of the power by the Chief Justice of India to achieve the constitutional purpose. Thus, the executive element in the appointment process is reduced to the minimum and any political influence is eliminated. It is for this reason that the word consultation instead of concurrence was used, but that was done merely to indicate the absolute discretion was not given to anyone, not even to the Chief Justice of India as an individual, much less to the executive, whenever which earlier had absolute discretion under the Government of India Act. Now, Lordship may kindly see my Lord Justice Pandyan's judgment at page 567, para 203. This is the concurring judgment, my Lord. Even though all constitutional functionaries have their own constitutional duties in making appointment of judges to the Superior Court, the role of one of the principal constitutional functionaries, namely judiciary, is incomparably immeasurable and incalculable. The task assigned to the judiciary is no way less than those of other functionaries, legislative or executive. On the other hand, the responsibility of a judiciary is of a higher degree. As frequently say, judiciary is the watchdog of democracy. Lord, I'll add it, Lord, even the Election Commission is the watchdog of democracy, checking excessive authority on other constitutional functions beyond the ken of the Constitution. It cannot be disputed that the strength and effectiveness of judicial system and its independence heavily depends upon the caliber of men and women who preside over the judiciary, and it is most essential to have a healthy independent judiciary for having a healthy democracy, because if the judicial system is crippled, democracy would also be crippled. My Lord, I'll just request your Lordship as my submission to read, my Lord, as an independent election commission instead of judiciary. Same principle would apply, my Lord. And in the 4 judges case, my Lord, which is 2016 5 SCC, page 1. My Lord Justice Kehar's opinion, page 422, para 307. My Lord Justice Lokur opinion, page 681, para 968. And my Lord Justice Goel's opinion, page 708, para 1034. Page 3, para 307 first, my Lord. Page 422. When an issue of such significance as a constitutional position of judges of the higher judiciary, it would be fatal to the independent, to depend upon the moral strength of the individuals. Judiciary has to be manned by people of unimpeachable integrity who can discharge their responsibility without fear or favor. There is no question of accepting an alternative procedure which does not ensure primacy of judiciary in the matter of selection or appointment of judges in the higher judiciary. And in the matter of transfer of judges, it is above position that it is not possible to conclude that the combination contemplated for in the NJSC is such that would not be susceptible to any breach of the principle of independence of judiciary. Then Lordship may kindly come to my Lord, page 681, para 968. What Justice Lokur has said. Given Given our constitutional history, the established convention, the views of various committees over the last 70 years, Lord, here also the views of several committees, and in view of the scope of legal luminaries, beginning from Motilal Sitalwal, and the theories of through the judiciary has gone through over several decades, the position in our provision of our constitution, I hold that Article 124, capital A, introduced by the in the Constitution by the 99th Amendment Act, impinges on the independence of judiciary and in the matter of appointment of judges, which is fundamentally an integral part of the independence of judiciary and alters the basic structure of the Constitution. It is accordingly declared unconstitutional, and other provisions of the Constitutional Amendment Act cannot stand by themselves. Therefore, they are declared unconstitutional. Similarly, NJC Act confers arbitrary, uncharted power on the various authorities under the statute, violates Article 14, is declared unconstitutional. And similar is the observations, my Lord, of Justice Goel, my Lord. I have given the para numbers. So, Lord, what my submission is, Lord, the same principle would be applicable so far as the, my Lord, independence of Election Commission is concerned. And Lordship asked me, my Lord, where is the direction for Parliament to frame a law? In the ADR case regarding, my Lord, would your Lordship kindly see, my Lord, come to volume 4 now. The two judgments. Your Lordship struck down parliamentary legislation, but it does not comply with it. The principles which were laid down in an earlier judgment. If your Lordship kindly come to
para numbers.
Para number, my Lord, volume 4, ADR judgment is, my Lord, at page 26, para 45 and 48.
45 and 48.
48. And the second judgment is PUCL, where the paragraph number is, my Lord, 112 and 113. Page 99 and 100. First, page 26, my Lord. This also says, till law is made to fill the vacuum. Finally, may I read that, my Lord. In our view, this court would have ample power to direct the commission to fill the void. In the absence of suitable legislation covering the field, and the voters are required to be well informed and educated about contesting candidates so that they can elect a proper candidate for their own assessment, it is the duty of the executive to fill the vacuum by executive order, or it is the content so till a legislation is made. And in para 48, certain directions are given, my Lord, as to what are the declarations which are necessary to be given to the voters. That you have to give these 5 declarations. That is the judgment, my Lord. And it also says, my Lord, it is stated the Election Commission has given instruction to meet the situation where the field is unoccupied by legislation. So till they occupied. Now legislation is made, my Lord, which your Lordship would get at page 50 of this same compilation. In the second judgment, where section 33 capital A and 33 capital B is introduced in the RP Act, where all these requirements are not there. And what your Lordship has said, my Lord, in page 99 and 100, para 112 and 113, that it is contrary to the ADR judgment, that's why it is struck down. Para 113, my Lord, may I read that? Because 12 is also important. It is settled principle.
Read the entirety of it.
Madam,
Please read the entirety of 112 and
112, my Lord. It is settled principle of constitutional jurisprudence that only way to render a judicial decision ineffective is to enact a valid law by way of amendment or otherwise, fundamentally altering the basis of the judgment either prospectively or retrospectively. The legislature cannot overrule or supersede a judgment of the court without lawfully removing the defect or infirmity pointed out by the court, because it is obvious that the legislature cannot trench on the judicial power vested in the court. Relying upon this principle, it is contended that the decision of the apex constitutional court cannot be sought at naught in the manner in which it has been done by the impugned legislation. As a sequel, it is further contended that the question of altering the basis of the judgment or curing the defect does not arise in the instant case, as the Parliament cannot pass a law in curtailment of fundamental rights recognized, amplified and enforced by this court. Para 113 is important. The contention that the fundamental basis of the decision in ADR has not at all been altered by the Parliament does not appeal to me. I have discussed at length the real scope and ratio of the judgment and the nature and character of directions given by this court to the Election Commission. As observed earlier, those directions are pro tempore in nature, and where a vacuum is filled, where once the Parliament stepped in and passed a legislation providing for right to information, maybe on certain limited aspect, the void must be deemed to have been filled up and the judgment worked out itself, though the propositions laid down and the observations made in under Article 19(1)(a) on the need of to secure information of the citizen will hold good. Now, new
Lead
legislation.
judgment. This is the concurring judgment.
I'm so sorry, my lord. It's a concurring judgment, my lord. It
It's
is
not the lead judgment.
no, my lord. Both the honor my lord. This is a judgment by two honorable judges,
Right.
and
This is the judgment you are reading is that of
it is by the concurring judgment of Justice
Justice
Reddy.
Reddy.
Justice Reddy, my lord. And the similar view I'll read, my lord. Justice Shah also says.
The situation is not quite the same, Mr. Ansari.
I'm so sorry, my lord.
Situation is not quite the
My lord,
same.
situation is
It was only to fill up the vacuum
yes, my
to
lord.
be operative till the law is made.
Yes, my lord. Here also, my lord, till the law is
No observation in the judgment
yes,
that the law should be framed in a particular manner.
my lord. Lordship, my lord. In the ADR
In-
case
in
also,
the Constitution bench, there is no such observation. That is why we asked you.
my lord. That's what I'm submitting, my lord.
Today,
to
a
correction.
contention can be raised that the law is contrary to the five-judge bench judgment.
My lord, the ratio of the five judgment, my lord.
If the five-judge bench had gone to this extent of saying that in framing the law, the parliament should bear
Lord,
in mind our observation.
Please, your lordship.
Even that is also not there.
Please, my lord. Subject to correction by my
Instead
letter.
of-
My lord.
We would invite you to
Please, your lordship.
assail the law
Yes, my lord.
on other grounds.
Yes, my lord.
Don't assail it only on the ground that
My lord,
it is contrary to Anup
my lord,
Patwal.
my lord, I'm not
Please
assailing
take a
only on
different line.
I'm assailing on the ground of the constitutional principle which your lordship have laid down in Anu Barnawal and summarized it, my lord. The constitutional requirement is, my lord, an independent election commission. Whether, my lord, the power, my lord, would your lordship kindly see, my lord, the position is even worse than it was earlier. Earlier, the president was to appoint on the advice of the Council of Ministers. Now, my lord, it's only the Prime Minister and his chosen minister. And your lordship, my lord, I have a list of dates.
But LOP is also there.
My lord, majority, my lord, earlier it has to go to the cabinet. Now, how it has been done in this case, my lord, illustrative example. Would your lordship permit me to place a list of dates, my lord, which is a part of your lordship's interim order in the present case, where it has been shown LOP has been given the list of 200 members on the previous day, and on the same day is given a list of, my lord, would your lordship just, let it very,
It was recorded in the interim order.
my lord, may I just, because your lords, both of your lordships were not there, my lord, may I just give
I
it,
was there.
my lord Justice Devta was there, my lord. That's why I'm saying both of your lordships.
You told us this.
No, my lord, this is very important. Would
You
you,
told us all this yesterday also.
no, my lord,
The list was so long and all those.
no, my lord, how, would your lordship just permit me to place it, my lord? Just give me my copy.
Okay.
Just give it to the other side. Huh. It is how, my lord, it works. When you will have a section 7 like this provision, this is how it works out, my lord. This is only to illustrate that. On 1st of February, my lord, the search committee and select committee, both are appointed. The search committee is, my lord, of the minister, the home secretary and the secretary personnel. The selection committee is the prime minister, the home minister appointed by the prime minister and LOP. On 4th of February, notice is given for convening a meeting on 7th of February for filling a vacancy of one election commissioner. However, the meeting was not held. On 9th of March, notice was issued for issuing the meeting of the selection committee of one election commissioner to be held on 15th March. On 9th March, Mr. Arun Goyal, election commissioner, tenders the resignation, which was accepted on the same day, resulting in the second vacancy. So, my lord, on 9th March again, a note was issued for the meeting of the selection committee of selecting two election commissioners instead of one, and the meeting was preponed to 14th March. On 12th March, some IA is filed before your lordship, my lord, for stay. On 12th March itself, my lord, the LOP or writes to the legislative secretary to share the details of the shortlisted candidates. On 13th March, this is very important, my lord, secretary writes, send a list of 200 names being considered by the search committee to Mr. Adhir Ranjan Chaudhary. As the search committee could not shortlist the names, It's only on 14th March, the search committee recommended a panel of 6 names instead of 10 names because there are 2 posts for consideration of the selection committee for selection of 2 members and circulated it to the selection committee. On 14th March, the selection committee met and recommended the names of Mr. Ganesh Kumar and Mr. Sukhbir Singh Sandhu to the president for appointment. On 14th March itself, the President of India appointed Mr. Ganesh Kumar and Dr. Sukhbir Singh Sandhu as the election commissioner. On 15th March, Lordship said, my lord, the matter would be listed on 11th March, and on 22nd March, Lordship dismissed it that as an interim stage, my lord, we will not do it, and it is a reported judgment which I have annexed it along with this this compilation. The next page is, my lord, I have shown to a Lordship, my lord. This is the schedule, my lord, which I have given in my written submission. I have just tabulated the scope and extent of the power only on that. So, my lord, this is what happens, my lord, when you give absolute power to one individual instead of even the Council of Ministers. Now the Council of Ministers also goes. And the LOP is given 200 names. My lord, can a collegium, my lord, function in a manner? Is it a collegium, my lord, with great amount of respect? When you dump to
14th March 24,
yes, my lord.
selection committee recommended the names.
Yes, my lord.
These 2 officers were in-service officers or they are retired?
That, my lord, I think Mr. They were both this Ganesh Kumar and Dr. Sukhbir Singh Sandhu.
They were in-service officers or retired officers?
We'll check and get it.
Huh?
We'll check and get it.
My lord, I don't want to make a statement. I'll just check it, my lord, and inform your lordship.
Kumar was not in Delhi.
Mr. Shankar, can you tell us?
Mr. Ganesh Kumar was not.
My lords, I'll get back after lunch with the answer.
Was-
I don't want to make a statement.
No, don't. He was appointed as the election commissioner. And I must check my mobile, my lord, and give it from the mobile.
Sorry for the
He's a retired 1988 batch officer, retired as second.
There's a 12 o'clock matter. Now, this seems to be going on. So, Lordship,
12 o'clock, kya matter?
there's a matter of mine, my lord, relating to
Huh?
What is item 120?
its maintainability of a suit, my lord, where NCLT has jurisdiction. It's one of those. It's covered by, in my favor, by Lordship Justice Datta's judgment. But anyway, that I will show, my lord, when it comes.
All submissions on merits will be reserved when we start.
I just,
We'll keep another day.
right.
Great.
I'm only requesting if we can just remain in the board in the same position. That's all. That's all I'm
Right,
requesting.
right.
Great.
Lord, Mr.
Dates on-
Today it will not.
Mr. Ganesh,
Let it just continue on board. That's all I'm requesting.
Lord, Mr.
Yeah.
Lord,
Grateful.
I'm checking.
Just 1 minute.
I'm so sorry.
I'm so sorry. Mr.
Deeply honored.
Great.
Sukhbir Singh, great.
I'm so sorry.
I've seen that. Yeah, I've seen that. Huh? All right. Yes, thank you. Lord, so far as Mr. Ganesh Kumar is concerned,
One more,
I'm so sorry.
one more thing. This section 6 is search committee.
Yes, my lord.
So the requirement of law is not that the search committee will forward all names to the selection committee people.
Yes.
It's the search committee.
10 names. So,
5 names for one member.
5 names.
5 names.
But you made a statement that a list of 200 names was
Well, forwarded, my lord, that is part of, not by the search committee. The secretary,
Search committee was required to send 5 names per vacancy.
on
That means 10.
months of the extension, yes.
So
All
they
right,
sent
just, yeah,
names
just,
of all 200. This is their claim. Because such committee could not shortlist.
this is part of the affidavit of the government of India, my lord, when the lordships are considering the interim order.
So no search committee has not recommended those 10 names. In fact, they have recommended.
No, my lord, no, my lord. 200 names were forwarded by the secretary of the legislative department to Mr. Adhir Ranjan Chaudhary, saying that the search committee has not finalized the names.
Okay.
On the same day, 14th March, when the meeting took place, on the same day, the search committees forwarded 6 names, including these 2 gentlemen.
So it means they have done screening.
And on the same day, the meeting is held, my lord, maybe in a,
So 6 names are forwarded.
yes, 6 names were forwarded by the search committee. On 14th March, when the meeting is to take place, Lord, how can it is expected that, my lord, the person can be, there can be effective and meaningful discussion or a fact finding? And your lordship asked me whether, my lord, both the persons were retired. Mr. Ganesh Kumar was superannuated. Both were retired in January 2024. and appointed in March
You
20.
can only say we wish this speed is maintained for appointment of judges.
Yes, my lord. Particularly High Court judges, my lord, which your lordship has seen. This court, my lord, fortunately have almost full strength, but the High Courts have.
Election commissioners are at par with Supreme Court judges.
Yes, my lord.
Everything happens on 14.
Search committees, I'm so sorry.
तो इसके बाद वो पैटर्न 422
वो compilation दे देंगे 5 volume 5. Urgency is 15th March is the hearing
15 March is the hearing.
of the stay application.
Oh,
So search committees, selection committee, presidential appointment.
that's the hearing. That is why. When the court directed that the matter will be coming on 15th. When
Lord,
did the court
Lord,
direct?
that I got it from your lordship's order, my lord. That order I did not find. I must be very candid. I was trying. Your lordship's order, I have annexed, my lord. With this, at page 3, it says, if your lordship kindly come to this judgment, which I have annexed along with this, I did not find, my lord, in the order sheet. I must be candid. But your lordship has recorded. That's why I have put it, my lord, in my list of dates. In the 2024-9 SCC, in this case where the interim order is denied, application for stay was filed, mentioned and directed to be listed for hearing on 15th March 2024. Just see this. SCC online SC 487. Just see this.
Where do you get it that it was to be listed on 15th?
Yes, my lord, if your lordship see
Which order? Which order?
my lord, I have taken it from your lordship's order of 22nd March by which stay was declined, in which para 3 of this order,
Para 3 of this order.
my lord, reported, it is a reported judgment, reported order, I will say, my lord, which is 2024-9 SCC 538 at 542.
Para 3.
The para 3, my lord, at 542, para 3 starts at 541.
No, we are looking into the ROP. It starts with that apart.
Yes, my lord, that apart. Then, my lord, towards the end of that, further, the writ petition challenging the virus of the act was sub judice before this Hon'ble Court since 2024, and therefore soon after the resignation of one of the ECs, applications for a stay were filed, mentioned and were directed to be listed for hearing before this court on 15th March 2024.
So in course of mentioning it was.
Yes, my lord.
So that-
I could not find, my lord. I tried struggling, but then it is there, so that's the reason I put it.
When a party mentions a matter, we say that
List it on
list
so.
on so and so.
Well, no, my lord, yes.
That
but-
is personal.
You got that?
Counter?
No, my lord. Despite repeated opportunities, my lord, and last opportunity was given on the last date.
No, I'm sorry. There is a counter, my lords, in Naman.
To the stay. To the stay application,
No,
there's an
it's-
affidavit which your lordship noted in.
Any of the
No.
Writ
There is a
petitions,
counter
no
affidavit, substantive counter to the writ petitions in the first matter, which is Naman Shrestha. I think writ petition
Naman?
11.
This is
Naman Shrestha.
30.33,
It is
Madam,
writ petition 11 of
34.2 में counter दिखाई नहीं था.
To the best of my knowledge, my lord, your lordship has on the last date said, just give me one petition. Last order says
That is there.
April.
there is. I am sorry, the Attorney General is also online.
Reply was to perhaps to the IA, which your lordships note in this order at page 4, para 4.
This is the counter affidavit in WP Civil 11 of 24.
11 of 24.
Lord, they served actually the same counter in my writ.
Huh?
They served the same counter in my writ petition.
No, one counter will do.
Correct.
One counter will do.
Actually give rejoinder to that also
Achha, there's a counter on my.
in our petition. We treated this as a counter in our petition.
Mr. Shankar, can you show us the paragraphs where you have dealt with this aspect of 14th March?
My lords, this counter is limited to the legal challenge.
Only legal, nothing.
Only the legal challenge. my lords.
No, perhaps there is a separate counter, my lord, because your lordships order at para 4 notes that the Union of India has filed a reply to the application for stay inter alia stating that these facts I have taken it from that affidavit.
This is the detailed counter to the writ petition.
Lordship, that was filed in the stay application, IA stay.
This is one affidavit. There is another counter
Yes.
to the interim.
To the interim application, which your lordship have noted in para 4.
And that was a detailed counter affidavit.
And the facts which I have put in my list of dates are taken from that order, my lord, only.
Can you attribute any motive without showing us that the union knew about 15th being the date when the matter would be coming up?
Yes, my lord.
Did they know about it?
If your lordships read your lordship's order of para 5, the same order,
22nd March.
it is highlighted, yes, it is
Just
highlighted by
just
the,
1 minute, 1 minute.
Yes.
22nd March, para 5.
it is highlighted. I have that. If your lordships are reading from your order, my lord, I'll just show that.
It's only records that it was advanced to 14th of March on 9th of March.
Yes, my lord. Yes.
Nothing more than that. But
No, but it says prior to the listing of the stay application.
prior to the listing, yes.
Yes, my lord.
Prior to the
So, my lord,
listing. But
so they knew, my lord, about the listing.
what you are suggesting is
Yes, my lord. Yes.
they had knowledge
Yes.
that 15th the stay application would
Yes.
come up.
Yes, my lord.
To frustrate the stay
Please, your
application,
lordships.
they did it on 14th.
14th, yes.
Union's defense is
Yes.
he had
Fixed
preponed the meeting on 9th.
9th March, yes.
And it was brought forward from 15th of March to 14th of March.
Please, your lordships, my lord.
So on 9th of March,
They did not.
when they
Yes,
preponed it, did
Yes.
they have knowledge that on 15th the stay application is coming up? So that is why they are bringing it to 14th to frustrate your rights?
My lord, these are.
Can you prove that?
My lord, I perhaps cannot.
So
My lord,
if you cannot, then we cannot,
No, my lord.
we
lordship-
cannot accept
No, no.
your claim.
Or let your lordship would accept is on 14th of March,
That is a fact.
Huh.
14th of March, there was
the super jet speed, my lord.
significant development.
Yes,
But when you are raising this point
yes.
and you want us to declare something as
Yes.
being, activated by motives.
Yes, my lord.
For that, you need to satisfy us
Yes, my lord.
that union also knew that
On 9th of.
15th,
Yes, is the date.
15th is the date.
I understand.
And that is why on 9th of March,
My lord,
it is brought forward to 14th.
to 14th March. My lord, perhaps I don't have any
If
material.
you don't have, then
My lord,
let us leave it at that.
Yes, but then what your lordship would see, my lord, when one person is in charge of the entire selection process, this is how it happens. There were search committee of minister and 2 bureaucrats, my lord, of the Government of India secretary officers. And there are, my lord, and the selection committee, two prime minister and his nominee minister. Out of 6 persons, only one is LOP, is, my lord, outside the government. And the LOP is given the list of 200 candidates. On the previous day, on the same day, 6 candidates. So whether there is any meaningful, my lord, discussion, my lord, or meaningful debate or discussion, my lord.
LOP raise any objection in?
Lord, I don't have the file,
You
my lord.
don't have nothing.
I don't have
You
the
don't
file, my lord, before lordship may summon the file or lordship may. Lord, but it does not, Lord, in my writ petition, I have not challenged. Lord, I may be very candid. I have not challenged this appointment and the stay has been rejected by our
On
lordship.
your writ petition, we cannot go into this question.
And LOP has also not filed any.
Lord, yes. Lord, this is so far as the stay was concerned, this was relevant, my lord. But today we are challenging the virus of the act.
Right.
And while considering the virus of the act, lordship would also take into account when a power is given to one individual. This is how it works. My purpose is to show only that, my lord.
Very good.
Then your lordship, my lord, yesterday asked me to give, my lord, the compilation of the relevant. I'm so sorry.
It's fine.
Please, your lordship. To give a compilation of the statutes, my lord, which have similar provisions for making the selection committee. I have given 8 statutes, my lord, where there's, and I have quoted the relevant sections, my lord, in that. I can take your lordship in the 4 committees. I can only say, my lord, in the aspect of Delhi Special Police Establishment Act, the Competition Act, the Lokpal and Lokayukt Act, and the Companies Act. CGI is a part of the consultative, is the part of the selection committee.
Out of 8 in these 4.
Out of this 8, my lord, in 4 act.
1, 4, 7,
1,
and 8.
4, 7, and 8. CGI is a part of the selection committee. In others, my lord, there are LOP in Lok Sabha, Rajya Sabha, Speaker, Chairman, Deputy Chairman. And my lord, Justice Rastogi, my lord, has summarized this, my lord, in para 444 of his judgment of his lordship judgment in Barnwal case, my lord. But I have given the relevant extracts from the relevant sections. Now give me one page. Where is my property? Just anyway. Record. It just doesn't matter. पहले कोर्ट को देने के साथ doesn't matter. एक कॉपी मेरे लिए.
In the Press Council of India,
Yes.
who can be the chairman? Qualification is there?
Press Council of India.
Press Council of India, page 3, Milan.
No, it is
Yes. Just a minute.
chairman of the council. What is the eligibility?
Yes, my lord. Just give me the act. You have the act. No.
One page you have missed. One page you have missed.
Besides Press Council Act.
I don't think any qualification as such is provided. Who can be member?
There is no qualification.
No. Section 5 only says consists of a chairman and 28 members nominated by a committee.
The chairman shall be a person nominated.
Yes, Lord, that's what I
That's all.
put. That's all. There is disqualification, Lord, in the proviso to subsection 3 of proviso. No working journalist who owns or carries on business of management any newspaper
Very
is
well.
eligible for nomination.
It's not there.
They are the members.
Very well. We have taken note 1, 4, 7 and 8.
Please, Your Lordships. Then I have my Lord, I have summarized my submissions in 7 pointers, my Lord, concluding submissions before Lords. Acha.
Just one time, petition.
Yes.
Which they are asking.
Just a minute. No, still clause me back. Secretariat. This is so that election. Well, all that your Lordship says in Bandwa, last concluding paragraph, 326.2, the court makes a fervent appeal to the Union of India Parliament may consider bringing in necessary changes so that the Election Commission of India becomes truly independent. That's the final word of your Lordship, Lord, in the Bandwal case. So, your Lordships, Lord, I don't think Lord, any judgment has been said that you issue mandamus to the Parliament or make a law in this manner. But your Lordship laid down the parameters, my Lord.
That cannot be done.
That cannot, my Lord.
That cannot be done.
Yes, your Lord. My Lord, may I just read this, my concluding submissions, my Lord. Independence of Election Commission is an essential feature of free and fair election in a democracy and is as much important as an independent judiciary. The independence can be ensured only if the executive does not have the dominant role in the appointment of the Election Commission. Prior to the Act, the appointment of the Election Commission was made by the President on the aid and advice of the Council of Ministers, vide Article 324, read with 74. However, under the Act, the appointment is the sole prerogative of the Prime Minister, my Lord, and is a minister chosen by Prime Minister. Under the constitutional scheme, the Election Commission cannot be chosen by the executive exclusively. This is apparent from the recommendations of various committees and the Constituent Assembly debates, as well as the decision of this Honorable Court in Hon'ble. The Act gives the executive, the government of the day, a decisive edge in the appointment process and weakens the institutional autonomy of the Election Commission. When a referee is appointed by one of the players, the credibility of the entire game collapses. The executive dominance in the appointment of the Election Commission creates a chilling and a real world impact on the electoral integrity and fairness. Schedule 1 of the propositions, pages so and so, shows the extent of power exercised by the Election Commission. And if the government of the day has the exclusive say in its appointment, the repercussions upset the very foundation of the democratic governance. A compromised Election Commission sets a dangerous precedent for the erosion of other independent institutions. It signals that the constitutional check can be reshaped to suit those in power, weakening the guardrails that prevent the majoritarian excesses. Democracy does not collapse overnight. It is hollowed out gradually through shift in institutional autonomies by compromising principles of checks and balances and swinging the pendulum grossly in favor of the executive. So, my Lord, my respectful submission, my Lord, this Act does not stand scrutiny of the constitutional scheme which the constitutional founding fathers have laid down and your Lordship has laid down, my Lord. I'm extremely grateful to your Lordship, my Lord, for giving me a patient hearing. And Lord, and word of acknowledgement, my Lord, my colleagues, my Lord, Kavya, Nandini and Asha has helped me a lot, my Lord, in this case. I'm grateful to your Lordship.
Madam, ये एक folder में रखिए. 1, 2, 3, 4. There are 4 volumes. Huh?
I appear for the Association for Democrats.
Enactment says volume 5. If anybody wishes to refer to it, it's in volume 5.
I have prepared, my lord, detailed written submissions in which I have quoted from whatever I want to rely upon. All the judgments I have quoted. May I just, my lord, show what happened in the
Your
debate?
case number is
87,
32 point.
32.33 है. 0.3. Before I read from the written submissions, my lord, may I just apropos your lordship's query as to what was discussed in parliament during the debates. Of course, as I said, we have stated in three places, in the synopsis, in the facts and the grounds, that majority of the opposition members were suspended during the debate of this particular law. However, Mr. Owaisi did say he was not suspended, and in the debate he does say something which is very significant, which effectively says that look, this law doesn't conform to the directions issued by the Supreme Court in Anup Baranwal's case. Now, unfortunately, my lord, in response to that, the government's response doesn't deal with that. It just says that Anup Baranwal asked us to frame a law, therefore we have framed a law. Essentially, it says that. And then they put the motion for voting, and it is passed by a voice vote. That's what happened in this case. I'll just show your lordship what Mr. Owaisi had said. In Mr. Hansaria's note, that compilation, it comes at page 190.
Of volume?
Volume 2. Volume 2. Page 190, in the middle of that page, my lord, at the top you'll see Mr. Asaduddin Owaisi.
Yes.
And then, my lord, in the second paragraph, after about 6 lines, he says, the search committee and selection committee, a total of 6 people, are involved in 2 stages. Out of these 6 people, there is only one independent person, that is LOP. Every other person either is a part of the ruling party or are officers who are serving with the government. Obviously, anyone they recommend will be a person who is acceptable to the government, and anyone with an independent mind will not be accepted. The allegation of bias will be difficult to defeat. What is the problem the Prime Minister, Mr. Modi, has in having the Chief Justice of India as part of the committee? The government has no reason to exclude the voice of the legislature and judiciary from the appointment. The appointment is now in full control of the executive, that is the Prime Minister. Having the CJI in the committee will add legitimacy to the ECI in the eyes of the public. By bringing such a legislation, you are ensuring that the legitimacy which the ECI enjoys now will decrease in the eyes of the common people. Honorable Chairperson, what is worse, under Clause 8.2, the selection committee can recommend the name of any persons even if they are not part of the list of names provided by the search committee, which Mr. Hansaria had mentioned. So what will the law minister do? And under Clause 7.2, an appointment will be valid even if the selection committee is not validly formed or even if the committee has a vacancy. The government is openly saying that once they have chosen a man or a woman, it cannot be challenged even if it is improperly done. So without an LOP, you can take anyone. Then, my lord, on the next page, 192, it says, second paragraph, I come now to clause 6. It provides that a search committee must be constituted under the chairmanship of the law minister. Who will appoint the two other persons? Will it be the law minister? Why create this facade? Say openly that the prime minister will appoint and get done with it. The law is unclear on who will appoint this committee, who will appoint the other two persons. More than this, it is obviously a political process with no independent or impartial voice to suggest names other than those accepted to the Honorable Prime Minister. Then, my lord, on the next page, 193, second paragraph, he then quotes Anup Baranwal. He says, in Anup Baranwal's case, in para 9, the Constitution bench of the Supreme Court has said, the executive alone being involved in appointment ensures that the commission becomes and remains a partisan body and a branch of the executive. The independence of the commission is intimately linked with the process of appointment. The Constitution bench in para so-and-so says the election commissioners, including the chief election commissioner, are blessed with nearly infinite powers and who are to abide by fundamental rights